Well, it's a pleasure to have on our program Professor Seth Barrett Tillman of Maynooth University in Ireland. Isn't that correct, Professor?
Well, we pronounce it slightly differently. Maynooth University.
Oh, good Lord.
I'm an American citizen. I live abroad. I'm not actually Irish.
I'm Philadelphia. We pronounce everything improperly. Now, Professor, how did you become like the world-renowned expert on the appointments clause?
I don't think I'm exactly the world-renowned expert, but I started publishing on the language of the constitutions and its usage of the word office and officer back in 2007, and I've published actively on that pretty much every year since then. So, my friends, not just my friends, but people who didn't like me told me in those early years, Seth, you shouldn't publish on this stuff. No one's ever going to be interested in it. It's never going to be litigated. But I thought it was important, and I enjoyed it, and I kept writing and writing. And then when Trump exploded on the scene, all of a sudden my writing became sought after, almost accidentally.
Well, Professor, are you familiar with what took place in the courtroom today? The judge's questions,
I was there.
The arguments that were made? You were there.
I was there.
Okay, well, one of the briefs is your brief, and with Landmark Legal Foundation, of which I am chairman. Would you explain to the audience what took place in the courtroom today and what kinds of questions you were asked? Because obviously I have no idea. We don't.
Well, the first thing I'd say is that there are many fine judges in the United States, including the federal judiciary. And what I saw today in Judge Cannon's courtroom was a very well-prepared judge who had the law, the statute law, and the cases right at her fingertips. And that's a reflection not only on her, but her staff who must have prepared her. So what I saw today was the very best you'll see among trial court judges. Now, of course, I've never been in her courtroom before. I can't give you reflections on her life, but I could tell you what I saw today was excellent. And she asked questions of the sort that you'd expect from an informed person, hard questions to both sides, also hard questions to the three lawyers who appeared as amicus, including my lawyer, Josh Blackman, a professor at the South Texas College of Law in Houston. And what I could tell you is that I'm not in a position to predict how she'll rule, but I certainly left the day with a smile on my face.
So how did we do in the courtroom today, do you think, in terms of answering questions and making the presentation?
Well, let me give you an example. The government's position is that the special counsel is not just a special counsel, but is also what is called in the statute an independent counsel. Because if the so-called special counsel isn't an independent counsel, there's no money in the budget to pay for him. That is, the budget authority to pay is not written there to pay for special counsel. It's there to pay for an independent counsel. The problem with that argument that the government makes is that their own authorities that they cited in their own brief say an independent counsel is to be appointed when the government is seeking to investigate and or try a high-ranking government official. Now, that argument might work theoretically to try Trump in the District of Columbia for January 6th related events, but it makes no sense for the trial in Florida because by that time, Trump was already a private citizen. So there's really no budget authority for what the special counsel is doing in Florida. And I didn't hear any response from the special counsel today at all to that argument. As a matter of fact, I'd say that about several things that happened.
All right, Professor Tillman, I know we're limited in time here, so the first argument that was made about the budget issue, what was the response of the government? Did they have an opportunity, and what did they say?
They did have an opportunity to respond, but they didn't respond to that argument. At least they didn't on Friday. They may try to respond to it on Monday because there will be another hearing that will also talk about budget authority that day. I won't be participating in that one. The focus of my argument was on the office nature of the position of special counsel, and that was linked to the budgetary authority, whether the special counsel is also an independent counsel. That was just one argument that was made today that I don't think the government has a solid response for. The other argument, the one that was, that central to my particular brief, was that the position of special counsel under the more modern case law put forward by the Supreme Court really isn't an officer of the United States position at all. Because to be an officer of the United States and to have the authority to prosecute for the United States, you have to have what's called a continuing position, a position that exists through different holders of the position. And the position that the special counsel holds is local to him. It dies when he resigns or is removed. So it's not really an officer of the United States position, and therefore, under our modern thinking, that's our modern Supreme Court precedent, including the SEC versus Lucia case from 2018, you can't really consider, you shouldn't consider, and the special counsel isn't an officer of the United States, and therefore he's not in a position to investigate and to indict anyone, including former President Trump. That's my view, and to tell you the truth, I don't think the government had much of a response. It did have a response, but I don't think it was satisfactory.
What was the response?
Their response was that the discussion in the case law about continuity of position isn't really about continuity of position. It's about continuity of duties. As long as the duties are continuous, that they exist over a reasonable length of time, the position is also continuous. But that's confusing the duties as being not episodic, not temporary, and the position itself being permanent or continuous. And unfortunately, the government in this isn't alone. You'll find any number of commentators in the literature who confuse continuity of position with whether the duties of the position are episodic or temporary. But that's not what the case law says, in fact. And it's unfortunate that some people don't see that, but I expect that Judge Cannon will see it because several people have put that position forward to her in very clear language. That's my guess. It's my hope, but we'll just have to wait to see what the decision is.
How was the argument for the Meese-Mukasey brief? How did that argument go?
The judge was very interested in it. Former Attorney General Mukasey was there, and it was odd to see a former Attorney General of the United States moving up line with everyone else and search like everyone else. But that's a good thing. Yeah. It's a good thing that a former Attorney General is treated like everyone else. But it is an unusual thing to see. There was a lot of security in the courtroom. In the courthouse to get in and out. And I think their argument went over well. It wasn't the same as mine. It was a different argument. It was an argument that had been made in the papers, and it was teased out and developed, and several questions were asked about it. And the logic of that argument is that if the Attorney General really has the authority to appoint a special counsel, he could basically have shadow officers subject only to his exclusive appointments throughout the whole DOJ, basically displacing the functions of U.S. attorneys across the United States and of the central DOJ. And, it would be almost like the Attorney General would have a shadow government at his disposal, and that can't be right, and it can't be what the statutes mean, giving the Attorney General authority to appoint certain officers and officials. That wouldn't include a special counsel. That's that argument.
Mm-hmm. It's a good point, too, as far as I just don't see a whole lot of good arguments on the other side. I mean, I read what they wrote. You really have to twist it. Go ahead.
The strength of their argument really relies on a case from the 1970s, a very famous case, Nixon versus the United States. Mm-hmm. And a lot of time was spent whether that holding is one controlling or only persuasive, and whether that it really speaks to the issues before the court today, before the district court today. I have to say I was surprised that by the end of the hearing, the government seemed to concede by saying that even if it's not controlling, it's at least very persuasive, whereas I think when they came into the court and on their papers they said it's not a question of being persuasive, it's controlling. So I think there was a little recognition by the government that their case wasn't exactly as sound as it looked on paper.
Now, you spend most of your time in Ireland these days. This judge is under withering attack by the usual American media here. You had people saying that she is an amateur, that she's not up to the job. One lightweight lawyer went on TV, called her some horrendous name and so forth, and you have CNN laying out the case and the New York Times that other judges didn't want her to hear the case. So they're trying to really intimidate her through the media. Do you think this judge is going to be intimidated?
I think
from what you saw,
it's very unusual. I think from what I saw and from what I know about the judges I've met over the course of my life, judges are not easily intimidated, and certainly not by the media. They might try, but it's not going to work. If anything, you push a federal judge who has lifetime tenure, it's liable to backfire on you. It wouldn't be something I would try to do.
But you were impressed with her generally, correct? Her intelligence?
What I saw was first class. What I saw today was first class. Mm-hmm. Everything. Yeah. She had everything at her fingertips, and her questions were probing, and she probed both sides.
But you felt good about it. Why did you feel good about it? I know it's just a feeling, but why did you feel good about it?
The biggest concern a lawyer always has is not whether his arguments are the best, but whether his arguments are understood. That's really the biggest thing for a lawyer. If you could get your point across, you might not win the case, but at least you got a shot at it. I walked out of that courtroom thinking that this judge understood the arguments, including my own. And I felt good about that. And, that's where we are. When she's going to rule on it, I don't know.
But you know what, Professor? When a former Attorney General, he's not the youngest man on the face of the earth, goes all the way to Florida from New York and shows up in that courtroom, that shows the seriousness with which he holds his position, no?
Yeah, I think there's a lot to be said for that, but whether Merrick Garland was physically there or not, I think we could take for granted that everything that happened in that courtroom had the support of Maine Justice, including the Attorney General of the United States.
Mm-hmm. But it is amazing that two prior Attorneys Generals view it completely differently and conducted that. And so did Bill Barr. Bill Barr appointed two special counsel who were sitting United States attorneys. He didn't pick somebody off the street. Anyway,
look, I'm on your side. I'm not defending what the current Attorney General has done. I think it's been a mistake, including for budgetary authority reasons that I've already explained. But on the other side, we should recognize that what Merrick Garland has done is, has some resonance with a large part of the legal community who believe, rightly or wrongly, that there are historical precedents for what he's done. I think they're wrong about that, but there are arguments on both sides.
All right. Well, have a wonderful Shabbat, Professor, and take care of yourself.
Thank you so much for your time. Bye-bye.
All right. Bye-bye. Eccentric, no, Mr. Producer?